Hello, guys. Good evening, everyone. Welcome back to the channel. This is the House of Law, and I'm Attorney Al Jumrani. Belated Happy Mother's Day to all the mothers out there, to the mothers of my students, yung may estudyante kong mother na din, yan. Saka yung mga nag-feeling mother dyan. Okay. So, welcome to this live lecture on partnership, agency, and trusts, still part of civil law. And hopefully my second to the last topic for my civil law refresher course at the University of the East. Okay. Kamusta po kayong lahat? Sino po nandyan? Okay. Hi, Carlo, Julian, Ana Cortez, Ces, June, Miss Balindong, Sinen, Happy, Milan, Mr. Maglangit, and Mr. Cadilinia. And good evening po sa inyong lahat. And to those who are watching because they saw the posts on YouTube, welcome to this live lecture on partnership, agency, and trusts. Now, you must have observed that noticed in the bar examination syllabus for civil law that the partnership topic or the partnership subject has been transferred to commercial law. So, kaya medyo struggle for commercial law reviewers ang itong syllabus because some commercial law reviewers or lecturers would have to lecture on partnership. Pero I think I mentioned this before in the class na in some of the review centers, I still lecture on partnership considering na it's still part of civil law. And as a civil law lecturer, dapat cover namin lahat. No? So, ayan, like in academicus, I still lectured on partnership, notwithstanding the fact that it's already, the law on partnership is already part of commercial law. So, this lecture on partnership is, of course, part of my lecture today, but note that questions on partnership will be asked in your civil law as commercial law exam. So advanced review na rin ito. I know many of you are studying the subjects one at a time. So halimbawa, you want to study civil law muna tapos followed by another subject, ganyan. So if you want, you can reserve partnership as later on when you want to or when it's time to study for commercial law. Pero yun na nga. Hindi natin alam baka in the coming or in the next bar exams ang partnership ibalik na naman sa civil law. Justice Leonen has been experimenting a lot with the bar exams. He's been trying to make sure that the bar exam will be done in an efficient way, and kasama na rin doon is yung pag-create ng outlines whereby the related subjects will be lumped together. And we've always been saying na ever since naman na ang partnership, although it's part of civil law, but in reality or in practice, partnership is really commercial in nature because it's for the purpose of doing business. And so when you say business, syempre commercial law na yun, di ba? Alright. So yan. Marami na tayo. We are 30. Thank you very much. Ayan, 35 na ang nanonood sa atin. Ayan. Okay. Hindi nyo naririnig but I'm playing music in my headset para lang meron tayong vibe during this live lecture. I can't play it kasi baka hindi ako payagan ng YouTube na i-post ito because of possible copyright issues. So right now I'm having a party in my head. So ayan. Too bad yun naririnig. But it's a Spotify playlist. It's a beach playlist. Ayan, nakakamiss kasi mag-beach. So ayan. So at least sa playlist natin, pwede nating ma-feel yung beach vibe. All right, guys. So I'd like to begin now. Okay, ano muna? But some greetings first. Okay, andito na rin si Charisma, si Jessry. Oh, hi, Mr. Jessry. May utang pa ako sa'yo. Diyos ko, pero don't worry. Malapit na. Sinasabay ko lang inaayos ko lang yung schedule ko. Okay, Mr. Rosario, Charina, Michael Opelano, Mr. Lumabi, ang pinakamaswerte sa raffle, Nadine, Joseph, Jong Jurado, uh, Milot Manuel, si Miss Ana at ito, and of course si Dada. Ayan. I-promote na natin ang Dada's Gourmet Tuyo. Ayan. So everybody, if you're interested to try one of the best, if not the best gourmet tuyo in town, try Dada's Kitchen. Ayan. Ayan. Shout out daw. Sino ba mga nagpapa-shout out pa dyan? Shout out. Ayun. Shout out kay Doña Espiritu Marco. Ayan. Ang unang-unang subscriber dito. Unang-una daw. Ayan. Ayan. Si Mr. Ilagan is here. Ayan. Mr. Monterde is also here. Ayan. Oh, sabi ni Chesri, hintayin daw niya. Naku, kaya kailangan talaga matuloy. Okay. Yeah, so it's Data's Kitchen. You can find it on Facebook. Search nyo lang Data's Kitchen Gourmet Tuyo. Ayan. At saka mukhang mag-expand na rin sila, no? Mag-expand to other products. So just watch out for that. Ayan, because Data is one of the most entrepreneurial people I know. Paano daw ba umorder kay Dada? Umorder ka, wag yung aasa ka lang sa paraffol, ah. Speaking of which, thank you pala kay Mr. Osita sa paraffol. Ayan. Okay, so share the blessings. Okay. Alright guys, sige, simulan ko na. Medyo matagal to kasi 3 topics to. The last time, isang topic, minsan 1 hour, pero sige, we'll try this mga 2 hours. And as always, again, if you will still stay until the end, thank you very much. But if you can't, if you need to leave and then try to go back, or if you want to watch this again, nandito lang to sa aking YouTube channel. Okay. All right, guys. Let's begin. All right. So we'll start with the law on partnership. So we begin with the question, what is a partnership and what are its elements? So a partnership is a contract where 2 or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. 2 or more persons may also profit. Okay, sorry. Mali ang na-mute ko yung sarili kong mic. All right. I think we can proceed now. All right. As I was saying, the definition of partnership is found under Article 7067 of the Civil Code. A partnership is a contract where 2 or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. 2 or more persons may also form a partnership for the exercise of a profession. For purposes of distinguishing the two, the first type under this definition is your ordinary partnership, which is sometimes called the business partnership because of the intention to earn or gain profits. In the meantime, the second type is your general professional partnerships, the purpose being to exercise a common profession. But either way, these two types of partnerships have the following common elements. So first is an agreement to contribute money, property, or industry to a common fund. And next is the intent to divide the profits among the parties or the intent to exercise a common profession in the case of a general professional partnership. Now, of course, remember that a partnership is a contract, so all the elements must be present. The elements that are mentioned in the case of Harantilla versus Harantilla are the distinguishing elements. Distinguishing because when these elements are present, then this contract is called a partnership as opposed to other associations or relationships because a partnership is quite related to other associations or memberships. Also, in property law, we have the concept of co ownership, and a partnership is distinguished from a co ownership when these elements are present. All right. Now, speaking of which, So are co-ownership, co-possession, and profit sharing indications of the existence of a partnership? Well, co-ownership or co-possession does not itself establish a partnership whether such co-owners or co-possessors do or do not share any profits made by the use of the property. Okay, because what is absent in a co-ownership or co-possession is the intent to divide the profits, meaning to say to make use of the property to earn profits and to divide the profits among themselves. The intention of co-ownership or co-possession is simply to jointly enjoy rights, property rights over a certain property. Now, next rule is that the sharing of gross returns does not of itself establish a partnership, whether or not the persons sharing them have a joint or common right or interest in any part in any property from which the returns are derived. So when you say gross returns, these are the returns of what they put in, no? Because this could simply be considered as interest or return of their investment, but not necessarily evidence of a partnership. However, the receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business. But no such inference shall be drawn if such profits were received in payment of the following. Okay, but first, let's emphasize that the difference between gross returns is just simply a return of the value of a thing, no? But when you say profits, it's the result of an what? It's a process whereby you use money to to create more money. So kaya siya tinatawag na profits. All right. So as stated, a return of money cannot be inferred as receipt of profits in the following situations. So, first, as a debt by installments or otherwise. So, because clearly the relationship there is a contract of loan and not a contract of partnership. Also, when the money is received as wages of an employee or rent to a landlord, because clearly the relationship is either employment or lease, also as an annuity to a widow or representative of a deceased partner. So again, because the receipt of the money there is for the purpose of alimony or support to a widow or to a separated spouse. Also, as interest on a loan, though the amount of payment vary with the profits of the business, and as the consideration for the sale of a goodwill of a business or other property by installments. Now, how does this become relevant? No? In case you will be asked the question whether or not a partnership exists, and in the facts you will find any of these. No? So, since Article 1769 provides that when the money is received as follows or as any of the following, then it is not a partnership. So you would know. So the answer to that question is that it is not a partnership because according to Article 7069, if the money is received as payment of the following or any of the following, it is not a partnership. All right. Now, very similar to partnership is a joint venture. In fact, a lot of companies or corporations or even individuals enter into a joint venture. But what law applies to a joint venture? Well, in several cases of the Supreme Court, it is said that a joint venture is actually a partnership. So, yes, a joint venture is considered a partnership. According to heirs of Tan Angki versus Court of Appeals and Realubit versus Haso, a joint venture is likened to a particular partnership or one which has for its object determinate things, their use or fruits or a specific undertaking or the exercise of a profession or vocation. However, both are different in the sense that a joint venture is limited to a single transaction, while a partnership generally relates to a continuing business of various transactions of a certain kind. So that's the distinguishing um, feature of a joint venture, that it is limited to a single or specific transaction as opposed to a partnership, which is usually for a more or less permanent or long term activity or undertaking. All right. Now, explain the following. What is the doctrine of the lectus personae, doctrine of mutual agency, and what is the rule that partners are guarantors of the obligations of the partnership? Sorry. Ayan. Pagka in-adjust mo talaga ang slide, nag-a-adjust din yung text. But anyway, you get what the question is, no? So what are these very important doctrines in partnership law? As I've always been saying, there are certain principles or doctrines that you must be familiar with, because every contract, every um, legal creation, okay, has certain features, important features. And when it comes to partnership, it's this: the doctrine of delectus personae, doctrine of mutual agency, and the rule that the partners are guarantors of the obligations of the partnership. So, under the doctrine of delectus personae, a partner has a right to choose with whom he wishes to associate himself. I don't know, but I literally translate delectus personae as the choice of the person. Ayan. So parang delectus, like choice, like it's delectable. So the food is delectable. So it's a food of choice. And of course, personae, person. Now, this doctrine of directus personae is very important in partnership, because partnership is not just any association whereby strangers can just join, or that it's an association that can be, um, uh, its membership can be changed. But rather, partnership is created based on trust, based on the belief that you are in a relationship that's convenient and beneficial to you and the other partners or the other people in that organization or association. So that's why you cannot expect strangers to join partnerships. There must be some personal trust among themselves to create the partnership or to join a partnership. And also, because of the delectus personae, it entitles or allows the partners or the members of a partnership to leave the partnership anytime, because the meaning of partnership is that it's only good for as long as it works. Okay, I know, based on that statement, you will say, sana all. Sana all ng partnership ganun, no? Like you can start and you can end when it's not working. But unfortunately, the delectus personae principle does not apply to all partnerships. And you know what I mean. Hindi mo pwedeng gamitin ang delectus personae in marriages, di ba? Because a marriage is a special contract. So hindi siya partnership, like the partnership that we're talking about. So hindi pwedeng delectus personae. So I woke up having this realization na hindi na kita mahal, so kaya ayoko na. Hindi pwedeng ganon. But in a business partnership, that is an acceptable ground to withdraw from a partnership or even to end the partnership. Because as I've said earlier, the partnership is good for as long as it works for the partners. All right, now the next is the doctrine of mutual agency. And under the doctrine of mutual agency, all the partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership. Okay, so later on we'll talk about the law on agency and explore or study the consequences of a contract of agency. But at this point, we should know that in a contract of agency, one party hires or engages another or appoints another to act as his agent or representative. So, as such, when this agent transacts with third persons, his transactions shall bind the principal. So, in the law on partnership, the partners are agents of the partnership. So, any transaction or any obligation incurred by the partners shall bind the partnership. Well, provided, of course, that the transaction or the obligation is in relation to the business or the nature of the partnership. So, this is the extent by which we apply the requirement that the agent must, uh, at least in the loan agency, you will recall that an agent must act within the scope of his authority. So, in partnership, the partner acts within his scope of authority when the transactions or obligations that he contracts are related to the business or the needs of the partnership. So, if the transaction or the obligation is personal to the partner, then that doesn't bind the partnership. Now, this doctrine of mutual agency may be restricted or limited once the partners elect a managing partner. Because once a managing partner has been elected or chosen, that managing partner has the exclusive right or authority to represent the partnership. And so the other partners, at least their right to um, participate in the management will only be limited now to either concurring or conferring the acts of the managing partner or to remove the managing partner. But once the managing partner is appointed, then he has the exclusive power and right to represent the partnership. All right. Now, next, the rule that the partners are guarantors of the obligations of the partnership can be found under Article 1803, okay, number one of the Civil Code. Also under Article 1816 of the Civil Code. And here, under the rule that partners are guarantors of partnership obligations, the partners are liable to the creditors of the partnership with their own property even beyond their contribution. Now, this is quite controversial because if you look at the civil code, walang sinasabi doon as to the procedure as to how creditors can run after the partners with respect to their subsidiary liability. But if we apply the rules on guarantee, at least we know now the procedure. And this procedure is that the creditor must go after the principal debtor before the guarantor. If you remember our lecture on guarantee and surety, the guarantor has the benefit of excussion. And under the doctrine of excussion, before the guarantor can answer to the creditor must have first exhausted all its remedies against the principal debtor. Of course, there is the obligation on the part of the guarantor to point to the available assets or properties of the debtor. Kasi kung wala naman siya maipopoint na property ng debtor, then pwede na siyang habulin ng creditor. Now, you might ask, well, isn't that parang speculation lang or parang alam mo yun, simply just interrelating provisions without any legal basis? Hindi. Because there is now a decision of the Supreme Court entitled Guy versus Gakot, whereby the Supreme Court said that a creditor of a partnership must first sue, okay, the partnership before going after the individual partners. And once the creditor has obtained a judgment against the partnership, and if this judgment was not successfully executed, then that's the time that the creditor can run after the partners, the individual partners. And the Supreme Court did not stop there because the Supreme Court said that the partners must be separately sued by the creditor. Why? Because these partners, despite their liability under Article 1803, number 1, and Article 1816 of the Civil Code, may also have defenses. Okay, so for example, when they were one of the usual defenses of a partner against a creditor who wants to run after him, no, for the obligations of the partnership is that this partner was no longer a partner at the time of the obligation, and in that situation his contribution to the partnership will be the one that will answer, okay, for the obligation, but not his personal assets. Kasi nga hindi na siya partner at the time the obligation was incurred. All right. So kaya maganda yung Guy versus Gakot. That should settle all questions as to ano nga bang procedure in running after a partner, okay, when the partnership credit has not been paid or settled. All right. Now, when is a partnership required to be in writing? Okay. Again, take note of the general rule under Article 1356 that all contracts are binding in whatever form. So whether it is in writing or verbal, that contract is binding for as long as the elements of the contract are present. Okay, but in these situations, a partnership contract must be in writing. So first is Article 14032A of the Civil Code, which is your statute of frauds provides that when by its terms the partnership agreement is not to be performed within a year from the making thereof. In other words, if the partners came together and they decided to form a partnership, but that partnership will only be executed, or meaning to say it will only commence after a year, then that contract should be in writing. Okay. Imagine high school friends and that they decided to, come together, nag-reunion, and then sabi, tayo kaya tayo ng coffee shop or milk tea shop. Or tayo kaya tayo ng gourmet tuyo. Ayan. So, kaya si Dada, malamang kasama doon. Okay. So, but then they decided na, well, let's give each other time to put up the money needed to start this partnership. So how about a year? Ayan. So pagka ganun, then that contract should be in writing, okay, to comply with the statute of frauds. Now, again, i-review lang natin pag sinabi naman natin statute of frauds, it's it's about the enforceability of the contract. The contract is still valid though among themselves, but that contract cannot be enforced in court because of a lack of evidence in writing. So kaya for purposes of enforceability, a contract of partnership which is to be performed after a year of the agreement should be in writing. Okay. Another situation where a partnership should be in writing is when immovable property or real rights are contributed thereto, and that is under Article 1771 of the Civil Code. Now, what are immovable property? Of course, these are land, buildings. Now, with respect to real rights, these are, for example, a contract of lease, okay, over a real property, and that lease is, of course, registered. No, so pwede yang i-contribute. Okay, so not only tangible real property or immovable property, but also intangible real rights can be contributed. So when these immovable properties or real rights over immovable properties are contributed, then the contract of partnership should also be in writing. Now, aside from being in writing, it should also be in a public instrument. And this is in compliance with Article 1358, okay, 1358 of the Civil Code. Yeah. Now, also, an inventory of the contributed property duly signed by the parties should also be attached to the public instrument. Now, in the case of Litunhua versus Litunhua, the Supreme Court said that this requirement is indispensable to the validity of the partnership. So, ito naman, validity na pinag-uusapan natin. Okay? So, if it is a partnership with real property being contributed, kahit isang partner lang ang mag-contribute ng real property. Kasi halimbawa, yung business is a small business and they just needed a commercial space. So one of the partners decided to contribute his own commercial building. So yun, kailangan yun in writing, in a public instrument, and also with an inventory. And that inventory is essential to the validity of the partnership. So tanong ulit, bakit nga ba kailangan ng inventory and what is this inventory for? The inventory is simply just a list of the property being contributed, the details of the property, as well as the value of the property. Now, the reason an inventory is made is because there is a transfer of ownership from the partner to the partnership. So, with that inventory, and once it is attached to the contract of partnership or partnership agreement, that partner now conveys his rights or ownership over this property that he is contributing, okay, to the partnership. Okay, importante. Otherwise, if there is no inventory, then it does not result in a transfer or conveyance of interest over that property. All right. Now, the other instance where a partnership agreement should be in writing is when the capital, meaning to say yung pera na kinontribute or yung pera na stipulated in the contract is at least 3,000 pesos. The capital is, of course, what fuels the partnership, okay, to do business. Okay, so kung ang capitalization is, let's say, at least 3,000, meaning to say, sabihin natin 10,000. Ayan. So, dapat it should be in writing. But if it's less than 3,000, then pwedeng hindi na siya in writing. But let's be realistic. Okay, how can you possibly start a partnership with less than 3,000 unless it's a micro business? But if the partners foresee a future in the business that requires, expenditures and all that, I think 3,000, sorry, not expenditures, but expansion. I'm sure 3,000 would not be sufficient. So if that partnership um, requires a capitalization of more than 3,000, so it should be in writing. So that's basically saying all partnerships should be in writing because the capitalization is more than 3,000. Now, aside from it being in writing, it should also be in a public instrument. And lastly, it should be recorded in the Securities and Exchange Commission. Okay. Now, in the case of Sunga Chan versus Chua, okay, the Supreme Court said that the failure to register the contract of partnership does not invalidate the same as among the partners, so long as the contract has the essential requisites, because the main purpose of registration is to give notice to third parties, and it can be assumed that the parties or the members themselves know of the contents of the contract after all. Okay, so yung registration ang hindi na required, no? The contract would still be valid and binding amongst themselves even if the contract is not registered. Now, speaking of the Securities and Exchange Commission, the SEC generally has jurisdiction over corporations because that's the mandate of the SEC. Pero bakit merong pa silang jurisdiction over bakit meron ba silang jurisdiction over partnerships when partnerships are governed by the civil code? Well, the answer is that the SEC, of course, by mandate of the law, is only overseeing or recording these partnerships, but the SEC does not issue rules and regulations to govern the relations of the partners or to regulate partnerships, unlike in the case of corporations na highly regulated ang mga corporations. With respect to partnerships, civil code pa rin ang nasusunod. So the relations of the partners are still governed by the civil code. Ang SEC will only accept contracts, will accept amendments of partnership contracts for purposes of recording. Pero hindi nire-regulate ng SEC ang mga partnerships. That's why ang SEC walang jurisdiction, for example, kung gustong tanggalin or kung gustong ibalik ang isang partner, no, in case merong problema among the partners, because these are not considered intra-corporate disputes, no, it's just an intra-partnership disputes, and the remedy of the partners is to seek judicial intervention. So diretso na sa court ang mga partners kung meron silang issues sa isa't isa. All right. Okay. Now, what are the rights and obligations of a partnership? Now, a partnership is a juridical person. And as a juridical person, it's like a person. So, meron siyang rights and obligations. So, let's start. As a juridical person, the partnership may acquire and possess property of all kinds. That's why if it's a real property, the partnership can have the property titled in its name. Okay? Pag sasakyan yan, pwede rin nakapangalan sa partnership. Now, also, a partnership as a juridical person may incur obligations. Okay. Also, it may bring civil or criminal actions because a partnership is a juridical person and therefore it is granted rights and obligations as if it were a natural person. Okay, by the way, the juridical personality of a partnership commences upon the agreement or the execution of the agreement, unless, of course, applicable yung requirement na it should be in writing for purposes of validity, which is in the case of a partnership where immovable property or real rights in an immovable property are contributed. Yun, kailangan yun for purposes of validity, right? So, kailangan siya in writing. But it's not the registration in the SEC that gives the partnership its juridical personality. Unlike in the case of corporations, both public and private corporations, which require a positive act other than or after, okay, the law or the agreement, no, before it can acquire juridical personality. So for partnerships, a partnership becomes a juridical person upon the execution of the agreement between the partners. But then third persons may require proof of that partnership. So, for example, when a partnership wants to borrow money from a bank may require proof that in fact this partnership exists. So, doon na ngayon hihingan ng either an articles of partnership or a registration with the Securities and Exchange Commission. Okay. Now, this juridical personality is separate and distinct from the personality of the partners. Thus, as a juridical person, the personality of the partnership is separate and distinct from that of each of the partners, according to Aguila versus Court of Appeals. So, what's the consequence of this ruling? It means that the obligations of the partnership are not the obligations of the partners, and obligations of the partners are not the obligations of the partnership. But with respect to obligations of the partnership, there is a subsidiary liability on the part of the partners. But that doesn't mean that these obligations are personal obligations. They are still obligations of the partnership. It's just that under the law, the partners are subsidiarily liable to pay the creditor, okay, in case the partnership assets or properties are not sufficient. Okay? Parang, again, as I said, guarantor lang. A guarantor, after all, is not the debtor. Diba? So, hindi siya debt. So, yung obligation ng principal debtor, hindi naman talaga yun originally debt ng guarantor. It's just that the guarantor makes a commitment to pay the creditor in case the principal debtor is unable to pay. So, ganun din sa partnership. So, the partnership obligations are not the obligations of the partnership or the partners. All right. Okay. Now, what are the rights and obligations? Okay, to be continued pala. All right. So next is that the partnership shall be responsible to every partner for the amounts the partner may have disbursed on behalf of the partnership plus interest, and for the obligations a partner may have contracted in good faith in the interest of the partnership business. All right. So also the amount to be refunded to the partners, okay, is necessarily limited to the partnership's total resources. Okay. So kaya priority pa rin talaga yung mga obligations ng partnership before the partners can get or collect their respective shares in the partnership. Okay. Now, what are the rights and obligations of the partners naman among themselves? Okay. So, rights first is the right to specific partnership property. So, as a partner, you have the right to enjoy and possess partnership property. Okay. So, this includes the right to use, let's say, a company car or the building where the partnership is doing business. Ganyan, no? But take note that this right of the partners to these partnership properties cannot be the subject of attachment, cannot be the subject of support or any other obligations in favor of a third person. So it's not a right that can be used, no, to answer for obligations of the partners. Usually, again, hopefully by next meeting, no, we can discuss the PPSA, Personal Property Securities Act. Um, Now, intangible personal rights over property can be a security for an obligation or a debt. So that's why, for example, if you are a buyer in a contract to sell, yan, personal right naman yun because hindi pa nga siya sale talaga. So you can assign that or you can transfer that. No? So as a result, you can also use that as collateral, yung intangible right na yun. But in the case of the partner's right to specific partnership property, that cannot be transferred, that cannot be attached, that cannot be used as security or collateral to pay for the obligation of the partner. Now, also, speaking of specific partnership property, no partner can have a better or exclusive right to these partnership properties. So if a partner is allowed to make use of a company car, the rule is that all other partners should be given the same right. Okay, so kung yung isang partner ginagamit niya yung paminsan nagagamit niya yung kotse paghatid sundo ng anak niya sa school, dapat yung ibang partners, they should also be allowed to make use of the company car for personal uses. Again, madali lang yan if there is an agreement, okay, among the partners. But generally, if they just want to be strict about it, all company property or all partnership property should be used only for partnership purposes. So hindi pwede for personal uses. Now, if they want to make use of this partnership property for their personal use, then that should be with the consent of all the partners. All right. The other right of the partners among themselves is the interest in the partnership. And this is the share of the profits and surplus. So if the partnership earns income and that income is divided among the partners. I mean, sabihin, meron silang agreement as to how much they'll be getting, then that agreement or the shares that they will get out of that profits or income is what we call interest in the partnership. Okay, now this interest in the partnership can be assigned, okay, or can even be shared, okay, with other persons, whether by gratuity or as security or collateral for the obligation of the partner. Okay. Unlike in the case of the right to specific partnership property, talagang yun exclusive partner lang ang pwedeng mag-enjoy nun. But in the case of interest in the partnership or the shares in the profits, then the partners can deal with a third person with respect to this interest or shares in the profits. So there are three arrangements or three agreements whereby a partner may deal or may dispose of his interest or share in the partnership profits. And these are your sub agency, assignment, as well as charging order. Okay. By sub partnership, not sub agency, sub partnership, a partner associates with another person for the enjoyment of his share in the profits. So, for example, a partner is receiving, let's say, 10,000 pesos every month as his share in the profits of the partnership, he can associate with another person with respect to that 10,000 monthly share in the profits. So this sub partner or this associate may receive, let's say, one half of it, one third, or depende sa agreement nitong partner at saka nung sub partner or associate niya. Okay? But take note that the sub-partner or associate does not become a partner of the partnership. He remains to be a stranger, okay, to the partnership because his contract or relationship is only with the partner with whom he is associated with. Okay. So now, if that partner later on withdraws from the partnership, his associate or sub-partner can no longer stay or can no longer get anything from the partnership. Kasi ang right lang niya, ang source ng right niya is yung partner kung kanino siya naka-associate. Okay, now this brings me to the case of professional partnerships. Let's say a law office or a law firm. A law firm has partners and also associate lawyers. These associate lawyers, well, theoretically, they are associates of specific partners kasi following the sub-partnership arrangement. Okay, but then, iba kasi ang setup ng business sa partnership, sa professional partnership. So, yung sweldo ng mga associates may come directly from the partnership or from the firm. Okay, so hindi from the partner. But as far as the practice of these associates are concerned, they are supposed to be assigned to a specific partner. Okay? So katulad din sa business partnership, yung associate is assigned to a specific partner. So, doon din siya kumukuha ng share niya or sweldo niya. But in in professional partnerships like law offices or law firms, yung mga associates are actually receiving their share in the income of the partnership or the firm directly from the partnership and not from the partners to whom they are associated with. Except siguro dun sa assignment at saka dun sa mga caseload, ganyan. So meron silang supervising partner. All right. Okay. The next transaction or dealing with the interest of a partner in a partnership is the assignment of interest in the partnership. So here, when you say assignment, the partner now assigns his rights to the profits, okay, or his share in the profits to another person. So this time, meron ng substitution. Okay? So the assigner partner now steps aside and the assignee steps in, okay, to receive all the profits pertaining to the assigner partner. But just the same, this assignee does not become a partner because his right is only with respect to the interest of the partner in the partnership. It's a different thing, however, if the partner is assigning his rights to the partnership. So in that case, mag-withdraw na siya as a partner. So ililipat na niya ngayon yung rights niya to the kumbaga ibibenta na niya yung rights niya doon sa ibang tao para itong new person will now join the partnership. So po pwede yung maging partner if the other partners agree or accept this new person. Again, dahil meron tayong doctrine of the lectus personae, they should agree. Hindi pwedeng automatic yun because hindi ito katulad ng corporation na the stockholders can just sell their shares to just anybody and that will take effect as soon as the sale is recorded in the stock and transfer book. But in the case of partnerships, pagka merong isang partner na aalis na at ibibenta niya yung shares niya or yung interest or yung rights niya in the partnership, dapat yung ibang mga partners, they should agree na papasok itong bagong partner. All right. So that's the difference between assignment of interest as well and assignment of rights in a partnership. All right. Lastly, on the interest in the partnership, the shares of the partner in the partnership profits may be the subject or may be subjected to a charging order. So, what is a charging order? A charging order is an order from a court, okay, in favor of a creditor of the partner, allowing the said creditor to receive such what is necessary, okay, to pay the obligation, okay, from the profits or shares of the said partner in the profits of the partnership. Kumbaga, para kang nag-salary loan. Okay? So yung partner may utang, dinemanda siya ngayon ng creditor niya, nanalo yung creditor, hindi ngayon nakapagbayad ngayon si partner, so kaya si creditor is allowed, okay, through a charging order to receive the shares of the said partner debtor, okay, uh, in the profits of the partnership. So parang salary loan nga na parang sa halip na ikaw ang tumanggap ng sahod mo, yung lending institution ang kukuha ng sahod mo. Alright. So those are the three ways by which a partner may deal with or dispose of his interest in the partnership. Okay. So again, by sub-partnership or association, by assignment of interest, and also by charging order. Okay, so the next right of a partner in the partnership is the right to participate in the management. And the right to participate in the management means to directly be involved in the running of the business of the partnership. But as I've said earlier, if a managing partner has been appointed, then the rights of the other partners with respect to the management would only be to concur or to confirm or to overrule the decisions of the managing partner and also to remove the managing partner. Because yun nga, the appointment of a managing partner is also for the um, effective administration or management of the business. Hindi pwedeng nanggugulo yung ibang mga partners. All right. And the last right is to demand a formal accounting. Now, a formal accounting is, of course, the process by which the partner who is responsible for making these accounts will make a statement or a summary of the affairs of the business and also to show kung magkano na lang pera or magkano pang liabilities ng partnership. Now, a formal accounting is not something that the partners can demand anytime. Under the civil code, ang mandatory accounting is done or made during dissolution, and also in those instances when there is a fear that the partnership business is being mismanaged. And also the other instance when an accounting may be made outside of the regular or the mandatory instances when accounting can be done is when an assignee okay, who is supposed to receive, okay, the shares of the partner assignor in the profits of the partnership, fears na mukhang nalulugi ako. Yung usapan namin, I'm receiving, let's say, 10,000 pesos monthly, pero bakit 3,000 na natatanggap ko? So there seems to be a mismanagement. So pagka ganun yung fear ng assignee, the assignee can ask for a formal accounting. All right, so take note of that. All right, next, what are the obligations of the partners among themselves and also in relation to the partnership? So first is to contribute money or property. That is one of the essential obligations because again, baga parang gasolina ang pera, no? For the equipment or for the machine, okay, to run, then it requires some fuel. So the contribution there is required for the partnership to exist and to run. Now, when a partner fails or refuses to contribute money or property, the remedy, according to the civil code, is to compel this partner to make good his contribution. In other words, pwede siyang idemanda, okay, for sum of money or specific performance because in that case, the partner becomes a debtor to the partnership. The remedy of dissolution is discouraged because hindi pa nga nagsisimula, i-dissolve mo na because again, the partnership was created with some aspirations of the partners to do business, to be successful, and all that. So the law wants to give the partners and this partnership a chance. So kaya hindi remedy ang dissolution. So instead, according to the civil code, if a partner fails to contribute, then he becomes a debtor. Therefore, the partnership can sue the said partner. Now, of course, siyempre pagka ganun may demandahan na, magkakaroon na ng strained relations among the partners. Kumbaga, di ba, why force yourself to work with people who have, again, sued you, no? So, kaya, posible later on, the partner, after, of course, being compelled to contribute, kasi kailangan talaga siya mag-contribute, yun yung agreement nila. Later on, because of strained relations, kasi nga hindi na nag-work ang partnership, he may decide not to proceed. So, aalis na siya. So, the partnership can, after all, still continue naman even if one partner decides to leave. Later on, we will look at grounds for dissolution of the partnership. At isa doon is when a partner withdraws, but it's just a ground. It may dissolve, but it doesn't mean that the partnership should be dissolved because the partners may just execute an amendment to the articles of partnership by either removing the partner who withdrew or by admitting a new partner. All right. Another business, but this time a negative, another obligation, not business, another obligation, but this time a negative obligation, mean to say an obligation not to do is not to engage in business. But the obligation not to engage in business varies or depends on the type of partner. Now, speaking of type of partner, there are generally two types of partners in a ordinary or even in a general professional partnership. And these partners are the capitalist partners and the industrial partners. A capitalist partner is a partner who contributes money or property. Okay. On the other hand, an industrial partner is a partner who contributes his industry, okay, to the partnership. So there are, after all, three possible contributions. You can contribute your property, whether real or personal. You can contribute money, and also you can contribute your industry. By industry, yan yung skills, services, pangalan mo, ganda mo, ganyan. Okay, so an industrial partner who contributes simply his industry is not allowed to engage in any business. Okay, kahit na personal business yan. So yung sideline. In my classes, I always use halimbawa, it's a computer shop, and then yung industrial partner is tasked with managing the computer shop. So siya yung nandun araw-araw, siya yung nagbubukas ng computer shop, siya yung nag-turn on ng mga computer, siya yung nagsisigaw na, oh, time ka na, ganyan. So, dapat nandun siya 100%. Well, like in all other partnerships, an industrial partner should give his 100% time and effort. And because of that, hindi siya pwedeng mag-sideline. So let's say yung nagbabantay ng computer shop, nag-decide siya na mag-online selling. Well, sa mga examples ko before sa mga classes ko is catalog pa nga eh. Let's say Avon, Boardwalk, ganyan, Natasha, ganyan. So that's also considered business. And to be strict about it, that's not allowed because that is taking away time, okay, that should have been devoted to the partnership. But there is, of course, an exception. And the exception is that when the other partners agree to allow this industrial partner to engage in personal or side business. Okay, now a capitalist partner, on the other hand, is prohibited only to engage in the same business. The idea being that it might compete with the business of the partnership. All right. Example ko lagi rin dito is that let's say it's a coffee shop. Now, this capitalist partner is also a supplier of, let's say, coffee. So, is there a conflict? Well, the answer is no because yung business naman niya is supplying coffee, hindi yung pagtayo ng coffee business. But let's say the same capitalist partner wants to put up a coffee business in another town, would that violate this prohibition? Well, to be strict about it, yes, because hindi naman sinabi ng batas na dapat in the same vicinity or the same city as the partnership. It's still the same business. But again, meron din tayong exception dyan. This capitalist partner may engage in the same business if the other partners agree. So lahat naman na pag-uusapan. Alright, now what are the sanctions? Banggitin ko lang, what are the sanctions if an industrial partner violates this provision on or this prohibition? Well, an industrial partner may be required to give or to deliver to the partnership everything that he has earned in that side business. And also, he can be held liable for damages. And lastly, he can also be removed, okay, from the partnership. In the case of a capitalist partner, his liability or his punishment will be to deliver to the partnership whatever he has earned in that other business or similar business and also to pay damages, mean to say to suffer the losses. Pero he cannot be removed. Hindi siya ground for removal of a capitalist partner if this capitalist partner engage in the same business. So you might ask me, bakit kaya ganun may disparity? Well, the simple answer is that an industrial partner has violated a simple issue of trust. No, so the issue there is you should give your time. No? So you're doing business, you have actually violated the trust of the partnership. Pero with respect to a capitalist partner, money lang kasi pagdating sa partnership sa capitalist partner eh. You are needed in this partnership because of your money. Okay, so as a result, we still need you. The partnership still needs you kasi nga yung pera mo, we need that. Okay, so but then because of your violation, then ito lang yung gagawin namin sa'yo. Alright. Now, the next obligation is to answer to the partnership for damages the partnership suffered through the partner's fault. Okay, so what are these faults? So, pwedeng by reason of negligence, by reason of malice or fraud in relation to third persons, tapos the partnership was made liable, then the partnership may demand damages from the said partners. All right. So what are the obligations of the partnership and partners, okay, to third person? So number one, all partners, including industrial ones, shall be liable pro rata with all their property after all the partnership assets are exhausted for the contracts entered into in the name and for the account of the partnership. So ito yung sasabi kong subsidiary liability of the partners. Okay. Now, ano itong ibig sabihin ng pro rata? In a partnership, marami tayong mga formula dyan. Una, formula in terms of sharing in the profits. Pangalawa, formula in terms of sharing in the losses. And lastly, formula in the sharing in the liabilities. Ito yon under Article 1816. With respect to the profits, okay, the first preference is the agreement of the parties. So if they have agreed in their articles of partnership kung magkano matatanggap nila as profits, then that should be followed. Pero kung wala silang agreement, as to the specific shares in the profits, then the basis of the sharing in the profits will be the contribution of the partners. So for example, if the capitalization is 1 million pesos, tapos there are five capitalist partners, tapos each of them contributed 20,000 pesos, ibig sabihin one-fifth of the capitalization, then that same one-fifth will be their share in the profits. Ayan. Assuming wala silang agreement as to the sharing in the profits in the articles of partnership or in the partnership agreement. All right. Now, with respect to the losses, ganun din, no? So, they shall follow the sharing in the losses as may be stipulated in their contract or in their articles of partnership, or if there is no such stipulation, then they shall follow the formula in the sharing of profits. Okay, so kung ano yung sharing nila sa profits, yun ang masusunod. Okay? Now, the reason is that, well, kumita ka, you should also shoulder the losses. Okay? So, yun. Now, speaking of sharing losses, sharing profits, kaya, paano si industrial partner na hindi naman nag-contribute ng capital, hindi nag-contribute ng money or property? So, the losses, a capitalist partner, an industrial partner should be given a share that is reasonable and that is fair and just, okay, to the industrial partner. So usually, based on what I've read, no, in cases and in experiences, ang share ng industrial partner in the profits shall be the same as the share of the least partner or least capitalist partner. Kung ano yung share niya, dapat parehas doon. Okay, now they can uh, they can start in the distribution of profits by first giving the industrial partner his share, tapos kung anong matitira, yun naman ang i-divide ng mga capitalist partners. All right. Now, but note that the industrial partner is not liable to share in the losses. Yung mga losses, mga capitalist partners lang ang liable doon. The reason is that the industrial partner has already given his time and effort to the partnership. So, wala na siyang mababawi. On the other hand, capitalist partners may still be able to get back something from the partnership, such as share in the partnership assets, no? Because they have contributed, okay, to the partnership, and also a return of their capital. So, dalawa ang makukuha ng mga capitalist partners upon dissolution. An industrial partner, however, is only entitled to receive a share in the partnership properties, pero wala siya makukuha from the capital kasi hindi nga naman siya nag-contribute ng capital. Now, with respect to liability, all partners, including industrial ones, shall be subsidiarily liable. But take note, the liability here is pro rata. So ano yung pro rata? Anong formula ng pro rata? It's not based on profits. It's not based on the formula of the losses, but rather based on the person, the number of partners. So if there are, let's say, five partners, then the liability of the partners shall be one-fifth. Okay, so for example, if the unpaid obligation of the partnership is 100,000 pesos, then therefore each partner shall shoulder or shall pay one-fifth of that obligation. All right, so yan po ibig sabihin ng prorata. Okay, by the way, any stipulation exempting any partner from this liability shall not bind third persons, but may be enforced only between the partners. Why? Because this provision is for the purpose of protecting third persons, and third persons are not privy to the agreement of the partners. So kaya hindi it's third person shall not be bound by this agreement between the partners, exempting some partners from liability, from subsidiary liability. But if there is such agreement among themselves, like for example, an industrial partner was exempted, no, kasi nga wala naman siya kinontribute na pera. So, and then they wanted this industrial partner or this person to be their industrial partner because of his expertise or competence or maybe networks or contacts. So kaya pang-attract sa kanya is that, sige, pagka merong liability ang partnership, hindi ka liable. So that agreement is binding only amongst the partners but not but it will not bind third persons. So magbabayad pa rin yung industrial partner or whoever partner is exempted from liability. Magbabayad pa rin siya dun sa third person. But he can ask for reimbursement from the other partners pursuant to their agreement. All right. Next is that the partnership is solidarily liable with the erring partner for the damages caused to a third person. So, stated differently, the partners are solidarily liable for damages, okay, with the partnership. So, what are these three instances under Article 1822, 1823, and 1824? Let me check kung nasa next slide. Ay, wala. Okay, so 1822, 1823, 1824 speaks of three situations whereby the partnership and the partners are solidarily liable to a third person. Okay, number one is when there is a misappropriation of money. So, for example, si third person nagbigay ng pera kay partner, pambayad sana doon sa partnership, but this partner who received the money misappropriated, okay, that money at hindi na turn over sa partnership. So the third person now is prejudiced. So this third person can sue both the partnership and the partner responsible, okay, or the other all the other partners for the return of the money and solidarity and liability. So any one of the partners or the partnership may be asked to pay. Also, the other instance is yung kabaliktaran naman, no? If the partnership receives money, okay, but this money was not used for the business of the partnership or kung ano man yung transaction ni third person, then both the partnership and the partners are liable. Okay, maganda example dyan na like ko rin sasabi is sa isang law firm, for example, may isang kliyente na lumapit sa partnership. So, normally, a partner will be assigned to speak to this client para kausapin, alamin kung ano yung kaso niya, and then also give legal advice. Now, the client was satisfied that this partner or that this lawyer is or is capable of handling the case. So nagbigay na siya ngayon ng acceptance fee. Nagbayad siya ngayon ng acceptance fee. Let's say the acceptance fee is 100,000 pesos. But this acceptance fee was embezzled or misappropriated by this attorney. So, walang nangyari. Hindi na-file yung kaso and all that. And the partnership was not even aware. Okay? Kasi hindi siguro sinabi ng attorney na, oy, nakuha ko na yung kliyente at nagbayad siya sa akin ng 100,000. So, the partnership and the other partners thought na, okay, it did not push through. Okay? This case with this client did not push through. So, hindi rin sila nag-follow up. Later on, this client sues both the partnership as well as the other partners for what that lawyer did. Okay, so that case will prosper because the partnership and the partners are solidarily liable to a third person for the misappropriation of the money. Okay, now of course the partnership and the other partners have a right of recourse against the partner, against that lawyer who embezzled the amount. Okay, so the third instance under I think Article 1824 is when the partner, while in while in the performance of official duties in relation to the business of the partnership, causes damage or injury to a third person, okay, through fault or negligence. Ayan. So bakit familiar? Because the same siya as the vicarious liability under Article 2180 of the Civil Code. All right, which we discussed previously in torts and damages. All right, so may a partnership be created by estoppel? Yes, the answer is yes, no? Because except as provided by Article 1825, persons who are not partners as to each other are not partners as to third persons. So what is this Article 1825? Now, the partnership by estoppel is a creation of equity, again, to protect third parties. So because it is to protect third parties, there must be some damage or prejudice caused to a third person. Okay, so under Article 1825, a partnership by estoppel arises when a person, by word spoken or written, or by conduct, represents himself or consents to another representing him to anyone as partner in the existing partnership or with one or more persons not actual partners. He is liable to any such person to whom such representation has been made or who has, on the face of such representation, given credit to the actual or apparent partnership. Ay na medyo mahaba siya. So ganito na lang yan. When persons who are not partners among themselves misrepresent or do acts, okay, that suggest that they are partners or that they formed a partnership, and by reason of such conduct or misrepresentation, a third person was made to believe that there was a partnership, and because of that belief, this third person parted or gave away his money or property, okay, to this partnership, then there is a partnership by estoppel. Just so this third person can recover from the said partners, alleged partners, and the partnership by estoppel, whatever that third person has given away. Okay, but take note that there is no partnership relationship among themselves because hindi nga naman talaga sila legal na partnership. Now, this brings us to the closely related concept of de facto partnership. Okay, by the way, de facto partnership is a partnership which is not de jure. Okay, so it's partnership de jure when all the requirements of the law have been complied with, meaning to say yung contract is valid and also they complied with the required form, okay, or registration, if any. Now, a de facto partnership is a partnership that fails or does not meet, okay, the requirements, although it is a valid partnership amongst themselves. All right? Hindi lang nag-comply doon sa formal requirements, kaya de facto partnership siya. Now, how is de facto partnership different from partnership by estoppel? Well, isa lang, the intention and the fact that there is a partnership relationship. Sa de facto partnership, that's present. But in a partnership by estoppel, it's not present. All right? Okay. Now, next is so what are the causes of dissolution of a partnership? So the following are causes of dissolution. So number one, those without violating the agreement between the partners. So ito yung mga instances na hindi naman siya in violation of the partnership but are deemed inherent, kumbaga given na this will cause the dissolution of the partnership. Examples are death of a partner, um, withdrawal of a partner from the partnership, okay, without violating the agreement between the partners. But, okay, if there is an agreement, for example, that the partnership will be for a certain term, let's say 5 years, okay? And then the partnership will, and then a partner will withdraw, or the two or more partners decide to dissolve the partnership, well, that would be in contravention of the agreement, okay? Because it will be by express will of any partner at any time in violation of what was stipulated in the partnership. All right. Also, by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. For example, prohibition against a partnership to operate a fish pond. Well, this is an old case, no? Okay, so um, before, there were certain businesses that were not open to partnerships, no? Well, meron pa rin tayong mga prohibitions diyan. Like for example, naalala ko lang just now, the practice of law, no? The practice of law cannot be practiced or cannot be exercised by juridical persons. So kasama diyan ang partnership. Pero ayan, baka confused na kayo. O bakit biglang sabi ni sir, hindi pala pwedeng mag-practice ng profession ng isang partnership? Eh bakit meron tayong mga law firm? Well, ang nagpa-practice naman talaga sa law firm ay yung mga individual lawyers or members or partners of the law firm, 'di ba? It's not the partnership itself, okay? But what we're saying is that juridical entities like corporations, business partnerships cannot practice law in the Philippines as it is, no, as a juridical person. All right. So in that case, then, if it's a partnership who has been found to be engaged in an unlawful business or practice, then it can be dissolved also. Also, when a specific thing which a partner had promised to contribute to the partnership perishes before the delivery, or when the thing, the enjoyment or use of which was transferred to the partnership is lost, and also by the death of any partner, by the insolvency of any partner or of the partnership, by the civil interdiction of the partner, and by the decree of court in the situations provided under Article 1831 of the Civil Code. Okay, babanggitin ko lang or discuss ko ng konti ito, insolvency, civil interdiction, and decree of court. So in the case of insolvency, this is a ground for dissolution because if one of the partners or if any of the partners becomes insolvent, therefore he cannot fulfill his obligations. No, for example, meron pa siyang obligation to contribute, no, because the obligation to contribute does not only exist at the time of the commencement of the partnership, but by agreement of the partners, they can also agree or stipulate that they will make further contributions during the term of the partnership. Like, for example, after 2 years, each one will give additional 50,000, and then after another 2 years, 100,000 naman. Ganyan, no? So, those obligations should be met. So, if one of the partners, or even if, let's say, the partnership becomes insolvent, then those obligations cannot be met. The other instance when insolvency will affect, okay, the partnership is when by reason of insolvency of the partners or the partnership, hindi rin mababayaran yung mga utang sa third persons. Okay? So yun. Now next is civil interdiction of the partner. Ha? Because in civil interdiction, which is an accessory penalty to certain crimes, no, like murder, robbery, and all that, yung mga serious crimes na yan, by civil interdiction, the accused or the convicted person loses his right to manage his property and all that, including his money. So therefore, hindi rin siya makakapag-comply sa obligations niya doon sa partnership. So civil interdiction there is a ground for dissolution. And lastly, yung decree of court. Ano ba itong mga situations na to? So these situations are the adversarial situations which can be disputed by the partner concerned. For example, insanity of the partner, or let's say a partner has done something that is prejudicial to the interest of the partnership. So yan, kailangan mong i-file sa court yan kasi i-dispute yan ng partner. All right. Now, after dissolution, how do you wind up or liquidate a partnership? So the manner of winding up is found under Article 1839 of the Civil Code. So first, there should be an inventory of the assets of the partnership, and then followed by an inventory or an accounting pala of the liabilities of the partnership. So in the asset list or asset column, nakalagay dyan yung mga assets of the partnership. So what are these assets of the partnership, or what properties are deemed to be partnership properties for purposes of liquidation? So these are the partnership property, meaning to say properties that are in the name of the partnership, and also the contributions of the partners necessary for the payment of liabilities. Okay, so these are yung contributions na expected from the partner. So halimbawa, hindi pa nakapagbigay pero nag-promise na, so that can be collected by the partnership. By the way, after dissolution, diba, winding up. So winding up is that stage or process whereby the partnership will collect debts, pay its obligations, and then settle everything. Kaya hindi na pwede ang new business, hindi na pwede ang new affairs. Okay. By the way, the assets now shall be applied or shall be used to pay for the obligations of the partnership in the following order. So, order of preference of liabilities of the partnership. So, ito yung mga unang mga babayaran. This is the hierarchy of the obligations of the partnership. So, first are those owing to creditors other than partners. Ibig sabihin, dapat yung creditor is a third person or is a complete stranger. Okay, next are those owing to partners other than for capital and profits. Ibig sabihin, those that the partnership owes to the partners by reason of some advances or by reason of some loans to the partnership made by this or extended by these partners. Now, third is those owing to partners by reason or in respect of capital. Okay, so kung ang capital ng mga partners are, let's say, 50,000 pesos each, so yan yung pangatlo na ibabalik ng partner sa mga partners. Capitalist partners lang. Kasi yung industrial partner, wala naman siyang ambag. Sabihin, wala siya na-contribute na pera. Of course, may ambag siya, di ba? Yung time and effort niya at saka yung ganda niya. Alright, now lastly, those owing to partners in respect of profits. Okay, kung may kita pa, then of course, these shares should be distributed. Now, take note that hierarchy yan. So, ibig sabihin, kung ang pera or ang assets ng partnership are not enough to cover one or two down the line, then hindi na mababayaran yung one or two down the line. Ibig sabihin, kung ang partnership assets were only sufficient to pay for the first in this list, then hindi na mababayaran yung number 2, 3, and 4. So, ganun din, pag ang partnership assets were exhausted pagdating sa number 2, wala nang makukuha for number 3 and number 4. So, after the exhaustion of partnership property, the partners will now contribute pro rata with their own property pursuant to Article 1816 of the Civil Code, yung subsidiary liability. All right. Now, what is the effect of continuing a dissolved partnership? Ibig sabihin, if there is a ground for dissolution but the partners did not decide to dissolve or to liquidate it, then the rule says the partnership can continue, but that the creditors of the old partnership are also the creditors of the new partnership. So hanggat hindi pa nababayaran yung mga first creditors, then they will have a claim, okay, against the partnership assets of the new partnership. And that is the case of Benjamin Yu versus NLRC. Although in this case, employee si Benjamin Yu. Although the Supreme Court said that an employee of an old partnership is deemed a creditor of that old partnership, and therefore he can claim from the new partnership. All right. Now, what is a limited partnership? Okay, sa civil code kasi last din in discuss ang limited partnership. Although limited partnership has become very frequent, no, because as you can see, a limited partnership has its benefits, and particularly its limited character, okay, becomes an attractive proposition to business people. So number one, well, first let's define it. It is formed by two or more persons having as members one or more general partners and one or more limited partners. So all it takes is just one general partner, tapos all the rest can be limited partners. Ang importante, merong isang general partner. The reason is that a general partner, that's why he's called a general partner, is because he shall assume all obligations, okay, in the partnership. So meaning to say, it's the general partner who will be liable to answer for the partnership creditors in case the partnership assets are insufficient, again pursuant to Article 1816 of the Civil Code. Limited partners are not liable with their personal assets. Hindi sila covered kay sa Article 1816. So exception siya doon sa Article 1816 na sinasabi na all partners, including industrial ones, shall be liable. Ang sinasabi na all partners, including industrial ones, are only those partners who are general partners. But if it's a limited partner, the limited partner does not answer with his personal property. Only his contribution to the partnership shall answer, okay, to the creditors of the partnership. Now, why is it limited? Well, it's limited because of the following. Number one, it is limited to as to liability because, yun na nga sinabi ko kayo na, the limited partner is liable only up to his contribution. He is not liable with his own property to answer for the obligations of the partnership. That's Article 1843, second paragraph of the Civil Code. Also, he is not a party, a proper party to proceedings by or against a partnership, except where the action is to enforce his right or its liability to the partnership. For example, pagka, albawa, hindi niya na ibigay yung kanyang contribution to the partnership, and therefore he can be a defendant in that case. No? Also, if he is liable under 1822, 1823, and 1824 of the Civil Code regarding solidary liability of partners and partnership to third persons. Okay? Solidary liability and for damages. Ha? Yung 1816, that's liability for unpaid obligations, contractual obligations yon. Pag negligent o pagka quasi-delict or obligations arising from negligence, that's liable dun ang mga limited partners. Okay, now it's also limited in the management because a limited partner cannot participate in the management. Only general partners can participate in the management of the partnership. If a limited partner takes part in the control of the business, he becomes liable as a general partner. So that's Article 1848. Now, lastly, is it last? Okay. It is limited as to the choice of contribution. So a limited partner may contribute only money or property and not industry. So all industrial partners are general partners. Okay? Although a capitalist partner may be a general partner or limited partner. All right. Now, also it is limited in the matter of firm name. The surname of a limited partner shall not appear in the partnership name unless, number one, it is also the surname of a general partner, okay, or prior to the time when the limited partner became such, the business has been created on under the name in which his surname appeared. So a limited partner whose surname appears in a partnership name contrary to this provision shall be liable as a general partner. Okay, so notice na it's a limited partnership because of the existence of a limited partner. But if this limited partner or partners violate this limited character or nature of the limited partnership, then said limited partner or partners become general partners. So that limited partnership ceases to be a limited partnership kasi nawalan na ng limited partner. Again, if you look at this list, simple lang, sabihin mo lang, well, if the limited partner insists that his name be found in the, or be included in the firm name, magiging general partner na siya. So, general partnership na yun. Okay. Also, if this limited partner insists on participating in the management by running or by offering himself as managing partner, then he ceases to be a limited partner, magiging general partner siya. So, general partnership na yun. Okay. So, same din with a contribution as well as if he offers his personal property to answer for obligations of the partnership to third persons. Magiging general partner siya and the partnership becomes a general partnership. All right. Okay. Now, what are the rights and obligations of a limited partnership? So again, halos parehas lang no sa rights of a general partner. Sabi natin apat 'yun, 'di ba? Right to specific partnership, interest in the partnership, right to management as well as right to formal accounting. Ang wala lang is yung right to management. Okay? Because a limited partner cannot participate in the management of the business. But in addition, eto na 'yon, 1851 1854 of the Civil Code. So inspection of the partnership books, true and full information and formal accounting of partnership affairs, also to demand dissolution and winding up by decree of the court, also to receive his share in the profits and to demand return of his contribution and to receive a pro rata share of the partnership properties. So basically that also these are also the rights applicable to general partners. All right. And what are the liabilities or obligations of a limited partner to the partnership? So of course to pay or deliver the contribution promised and also to hold in trust specific property or money which are to be contributed or delivered to the partnership. All right. Okay. That's the end of the partnership lecture. Okay, guys. The thing is, it's already 8 o'clock and it's been more than an hour. We can't continue this. Sorry talaga, I have to apologize. Maliban sa kayo medyo inaantok na siguro kayo at hindi nyo na kaya yung makinig ng ganong katagal. Ako din, masakit na rin ang puwet ko. Okay. So don't worry, I will make a separate recording for agency and trust, no? Again, sorry, hindi ko talaga ni-estimate. Akala ko kaya ko lahat ng 1 hour 30 minutes kasi we started 6:30 up to 8. But, okay, let's give ourselves a break. Okay, I will end this live lecture on this note dito sa partnership, no? Because the next topic supposedly is the loan agency, pero I'll just make a separate recording for agency, tapos of course trusts. So in the meantime, I will say goodbye. But before saying goodbye, I'd like to check who's here. Ayan, so thank you, Pia. Ayan, thank you, Jessry, for asking if kumain na ba ako. Hindi pa po ako kumakain. Ayan, syempre, mauuna talaga yung ating mga commitment. Ayan, our priorities. Ayan, oh, hindi daw mabasa yung slides. I'm sorry, Chris. Okay, but I hope you're able to listen. But siguro, you try to replay it later. Baka malinaw na siya. Anyway, so thank you very much. We are 54 in this live lecture. Thank you very much, everybody, for watching. Um, Again, my promise is I will record a separate lecture on agency and trust. Okay, but you will still find this lecture on partnership. I will just title it as a lecture on partnership para at least hindi namang ma-deceive yung mga mag-click dito tapos wala pala yung agency and trust. Kailangan ko na rin talaga magpahinga. Aray, sakit sa puwet. Ayan, okay. Normally, this bot can take anything. Joke. Anyway, but, okay. Sakit sa puwet. Anyway, thank you very much for listening, for joining me. Ayan, thank you very much, guys. I'll see you in my next video. If you're If you haven't subscribed yet, please subscribe to my channel and please click that notification bell so that you will be able to get notification when I put up a new video. Ayan. Good night, guys. Thank you. Ayan. Laging tatandaan, isip e buksan, alamin ang batas. Love you guys.